If you own a gun in America, the ground beneath your feet didn't just move, it split open. Right now, at this very moment, there are 10 massive legal changes in effect that could be the difference between exercising your constitutional rights and facing federal criminal charges. The terrifying part? Almost nobody knows these changes exist, not your local police, not the gun store owner down the street, and definitely not the mainstream media that should be reporting this. While the mainstream news cycle is obsessed with political theater, a massive, quiet, constitutional earthquake just finished tearing through every federal circuit in this country. A series of court decisions handed down between December 2025 and January 2026 has quietly rewritten the entire framework of American gun law. We are currently witnessing the total dismantling of 100 years of gun control framework, and as of this month, January 2026, 10 massive changes are already in effect. Law number 10 is so radical that what used to be a mandatory 10-year federal prison sentence is now quite literally your protected constitutional right. Hit that subscribe button and turn on notifications immediately. What I'm about to show you is the thin line between staying legal and accidentally walking into life-altering criminal charges. If you're operating on information from even 6 months ago, you are a sitting duck for a predatory legal system. The information in this video isn't political commentary, it is legal survival knowledge for the year 2026. Here's what makes this situation so dangerous. These weren't headline-grabbing Supreme Court decisions. These were circuit court rulings that quietly moved through the federal system while everyone was distracted by election news and holiday coverage. Court clerks filed the paperwork, judges signed the orders, and the legal ground shifted under 100 million gun owners without a single major news outlet covering the story. Legal experts are calling this the most significant reformation of gun law since the Second Amendment was ratified, but it's happening in almost total media silence. That silence creates a deadly trap. Right now, police officers are still enforcing laws that no longer exist. District attorneys are still prosecuting cases under frameworks that have been struck down, and gun owners are still following restrictions that have been declared unconstitutional. The system hasn't caught up to the law, and that gap is where innocent people get destroyed. The first and most explosive change is the constitutional reset. For decades, your Second Amendment rights were treated as second-class rights. Courts used a dirty trick called interest balancing. Basically, a judge could say, sure, you have a right to a gun, but the government's interest in public safety is more important. That era is dead. Federal courts have now mandated that any restriction on firearms must be rooted in historical tradition dating back to the founding era of America. If a similar law didn't exist when the Second Amendment was written, the modern version cannot stand. Under the finalized 2026 federal framework, every court in America is now mandated to treat your gun rights with the same strict scrutiny they apply to freedom of speech and religion. The government no longer gets the benefit of the doubt. Why does this matter to you today? Because it reverses the burden of proof. If a city wants to ban a specific type of firearm or magazine, they have to prove 3 things that are almost impossible to meet. They must show a compelling governmental interest, not a hypothetical fear, but a severe, immediate problem. The law must be narrowly tailored. It can't catch law-abiding citizens in a broad net. And here's the killer clause. They must prove there is no less restrictive alternative. If there's any other way to solve the problem without taking your rights, the law is unconstitutional, because almost none of the modern gun control framework meets this test. Assault weapon bans? There's no historical precedent for banning common firearms. Magazine capacity limits? Didn't exist in 1791. Waiting periods? No founding era equivalent. Sensitive place restrictions? The list of protected locations was tiny in the 1700s, not the sprawling list we see today. Legal analysts are already warning that 70% of existing state gun laws, from assault weapon bans to sensitive place restrictions, are now legally hollow. They are dead men walking, waiting for a final signature to be wiped off the books. Constitutional law professors analyzing these rulings estimate that between 40 and 60% of current state-level gun laws will fail this historical test when challenged. We're talking about thousands of regulations that are now legally vulnerable. The second massive shift is what's sending shockwaves through police departments from Seattle to Miami. It's the prohibition on prior restraint for gun ownership combined with officer accountability expansion. For years, states could require you to prove why you needed to exercise your Second Amendment rights before granting permission. It was called may issue permitting. You had to convince a government official that you had a good reason to own or carry a firearm. Self-defense wasn't automatically considered good enough. You needed specific, documented threats. A dangerous ex-spouse, a stalker, credible death threats. In places like California, New York, New Jersey, Maryland, and Hawaii, ordinary citizens were routinely denied permits because they couldn't prove sufficient need. Meanwhile, politically connected individuals, celebrities, and wealthy donors somehow always managed to demonstrate adequate justification. The system was arbitrary, discriminatory, and deeply corrupt. The new federal standard has demolished this framework. Courts have ruled that prior restraint, requiring permission before exercising a constitutional right, violates the fundamental nature of the Second Amendment. You cannot be required to justify why you need a constitutional right before you're allowed to exercise it. Think about it this way. Imagine needing to prove to a government bureaucrat why you deserve freedom of speech before you're allowed to speak, or having to justify why you need freedom of religion before you can attend church. It's absurd, and the courts have finally recognized that the Second Amendment works the same way. The implications are staggering. In New York alone, there were over 89,000 concealed carry applications that had been pending or denied under the old good cause standard. Under the new rulings, every single one of those denials is now legally void. Hawaii, which issued fewer than 200 concealed carry permits in the entire state last year, has been forced to issue over 4,700 permits in the last 45 days. But here's where it gets even more powerful. For years, a legal doctrine called qualified immunity worked like a bulletproof vest for law enforcement. If a cop confiscated your legal firearm without a warrant, you could sue the city, but the officer walked away scot-free. As of this month, that shield has been stripped away for Second Amendment violations. Courts have now ruled that enforcing a clearly unconstitutional gun restriction is no longer a good faith mistake. If an officer violates your established gun rights today, they can face direct personal liability. In a landmark case earlier this month, 3 officers were ordered to personally pay hundreds of thousands of dollars for an illegal seizure. They didn't just lose their jobs, they are losing their homes and their savings. Police supervisors are now issuing frantic stop and desist memos. The era of "I was just following the state's ban" is over. The third major shift marks the total end of red flag confiscation without due process. For years, the red flag system was a constitutional nightmare. An ex-spouse or a disgruntled neighbor could file a civil complaint, and police would show up at 3 in the morning to seize your property before you even knew a court date existed. You were guilty until proven innocent. Red flag laws, extreme risk protection orders, emergency seizure statutes, whatever you want to call them, they all worked the same way. Someone filed a complaint. Law enforcement showed up, usually without warning, and took every firearm you owned. No arrest, no criminal charges, just accusations and confiscation. You'd find out later that there was a court hearing, except you weren't notified in time to attend, or you weren't provided with an attorney, or the hearing happened based entirely on written statements you never got to challenge. The statistics are genuinely disturbing. Across the 19 states that had these laws, approximately 18,000 emergency seizure orders were issued last year. In 68% of those cases, no criminal charges were ever filed. In the 21 states that previously had these laws, over 15,000 people had their property stolen by the state last year alone without a single criminal charge being filed. The newest federal rulings have put a permanent stop to this. The court has drawn a hard line. Firearms cannot be seized without an arrest or a full adversarial due process hearing. This means no more ex parte one-sided orders. You have the right to confront your accuser before the guns are taken. You have the right to present evidence and cross-examine witnesses. But here's what almost nobody knows. If your firearms were seized under an emergency order within the last 3 to 5 years, you now have clear legal grounds to demand their immediate return and potentially seek damages. The problem? Most states have a 90 to 120-day statute of limitations to file these claims. The clock is ticking, and most people don't even know they have a claim. If you miss that window, silence is treated as consent. The fourth change addresses your digital footprint as a gun owner, and the scale of what was happening is absolutely shocking. For over a decade, the ATF was quietly building a searchable billion-record database by digitizing the paper logs of closed gun stores. Even though federal law explicitly prohibits a national gun registry, the government used a clerical loophole to keep your data indefinitely. For years, the ATF has been building an illegal national gun registry. Federal law requires gun store records to be kept in non-searchable paper form. The ATF ignored this and digitized nearly 920 million firearms transaction records, creating a searchable database of American gun owners. As of early 2026, that loophole has been welded shut. Federal courts have ruled that the indefinite storage of digitized firearm transaction data is a violation of the Fourth Amendment. The court has issued a hard 90-day deadline for the federal government to begin the permanent destruction of all searchable gun ownership databases not tied to an active criminal investigation. This isn't just about deleting a few PDF files. Independent forensic auditors are now being brought into the ATF's National Tracing Center to verify that these records are erased and, more importantly, unrecoverable. The ruling also mandates that any agency head who knowingly maintains these ghost registries now faces personal criminal penalties. But it gets worse. The database was actively used. Over 340,000 unauthorized searches were conducted in the last 2 years alone without warrants or probable cause. Early settlements estimate affected individuals could receive $15,000 to $50,000 per unauthorized search. But most people don't know their information was in this system or that they have valid claims. The fifth change shuts down government financial surveillance of lawful gun purchases. If you've ever felt like your search history or your credit card statement was being watched simply because you're a gun owner, you were right. For years, programs internally designated with names like GunWatch monitored digital footprints. If you bought bulk ammunition, searched for AR-15 parts, or visited certain firearms forums, you were moved to a high-priority monitoring list. Court disclosures confirmed the Department of Homeland Security, working with major financial institutions, operated programs that tracked firearms purchases through the banking system. Banks flagged firearms transactions. Credit card companies provided data to federal databases. Even PayPal and Venmo shared information, all without warrants. This has officially been terminated. The court's logic was simple but devastating to the surveillance state. Exercising a fundamental right cannot be used as probable cause to justify government spying. The new ruling makes financial surveillance of lawful gun owners illegal without warrants based on probable cause. What does this mean for you? Financial privacy? Banks and credit card companies are now prohibited from sharing your firearms-related transaction data with federal agencies without a specific judge-signed warrant. Geofencing bans. Law enforcement can no longer use geofence warrants to see who visited a gun range or a gun show. Search History Shield. Your internet searches for legal firearm topics are now constitutionally shielded. Over 2.1 million Americans had their records monitored without knowledge. Estimates suggest over 50,000 law-abiding citizens were being soft-tracked by these programs. Settlement amounts are expected to reach billions. Because of this ruling, class action settlements are already moving through the system, with potential payouts for those whose privacy was invaded without cause. If you live in a restrictive state like New York, California, or New Jersey, you know the permit game. They can't legally say no anymore, so they tried to make the process so slow, so expensive, and so annoying that you just give up. Some wait times for a concealed carry permit stretch to 18 months, with fees reaching nearly $1,000 in some jurisdictions. The sixth change is the permit processing overhaul, and it's a total game changer. The federal courts have issued a uniform mandate that every state must follow, the 30-day rule. If a state does not approve or deny your permit within 30 days of your application, it is now considered automatically approved under federal law. You no longer have to beg for your rights. The clock is ticking on them. The $50 cap. Total application fees, including fingerprinting and background checks, are now federally capped at $50. This is a massive blow to states that were using high fees as a poll tax for the Second Amendment. No good cause retaliation. If you were previously denied for a subjective reason, that denial is legally void and cannot be used against you in a new application. In cities like New York, we are seeing tens of thousands of stuck applications suddenly being processed in a matter of days. The era of the bureaucratic pocket veto is officially finished, but the permit overhaul means nothing without another critical protection: the background check time limits. Under the old system, the FBI could delay background checks indefinitely. NICS checks were supposed to be instant, but purchases were routinely delayed for days, weeks, or months during additional research. Your check would come back clean, but the FBI would initiate open-ended investigations, all while your purchase sat in limbo. The new federal standard imposes a hard 72-hour limit. If the FBI cannot identify a legal prohibition within 72 hours, the check automatically defaults to approval. No extensions, no additional research periods. Last year, over 47,000 checks were delayed beyond 3 days. Under the new ruling, all would have automatically proceeded. The FBI no longer has power to create indefinite bureaucratic barriers. For years, states like California and New York tried to backdoor gun control by attacking the supply chain. They treated ammunition like a controlled substance, requiring background checks for every box, banning online sales, and prohibiting you from bringing ammo across state lines. As of early 2026, the courts have finally stated the obvious. The right to keep and bear arms is meaningless without the right to acquire the ammunition those arms require. The new ruling states ammunition is constitutionally indistinguishable from firearms. Under the new federal mandate, ammunition is now legally protected to the same degree as the firearms themselves. The ammunition background check systems have been struck down as unconstitutional burdens. This means online freedom. You can once again order ammunition online and have it shipped directly to your door in all 50 states. No more registry. Retailers are no longer required to log your ID or report your ammunition purchases to state databases. The grocery standard. Buying a box of 9mm is now legally treated like buying a gallon of milk. Online retailers report sales increases over 400% in restricted states. An estimated 3,200 retail locations have resumed ammunition sales in the last 60 days. Between 2021 and 2024, the ATF's zero-tolerance policy was used to shut down hundreds of mom-and-pop gun shops for tiny clerical errors, like a missing middle initial or an abbreviated city name. It was a war on the industry. The eighth change marks the official repeal and judicial ban of zero tolerance. The new legal standard requires the government to prove criminal intent before they can revoke a federal firearms license. If it was a typo, it's a correction, not a closure. As of this month, the Department of Justice has been ordered to reinstate the licenses of dealers who were shuttered for non-willful paperwork mistakes. Applications for new licenses have increased 110% in the last 2 months. This has led to a 90% surge in new applications as people realize the regulatory firing squad has been disarmed. The ninth change is the permanent ban on administrative raids. Previously, federal agents could show up at a gun store or a private collector's home and demand an inspection without a warrant. If you refused, they threatened you with immediate arrest or license revocation. The court ruling this month makes the law crystal clear. Fourth Amendment protections apply to gun owners too. All inspections now require warrants based on probable cause of specific criminal activity. Federal agents are now prohibited from entering your property for firearm inspections without a specific warrant tied to an actual criminal allegation. Over the past 4 years, the ATF conducted approximately 2,800 warrantless home inspections. Those actions are now treated as Fourth Amendment violations. Settlements range from $75,000 to $150,000 per inspection. If an agent appears at your door today without a warrant, you have the legal right to stay calm, stay firm, and tell them to come back when a judge has signed off on a crime. This is the big one. This is the law that turns a 10-year prison sentence into a constitutional right. For decades, gun owners were terrified to drive through anti-gun corridors like New Jersey, Maryland, or Illinois. Even if your gun was legal at your house and legal at your destination, simply stopping for gas in a restrictive state could lead to a felony arrest. We all remember the horror stories. The Pennsylvania man traveling to a competition in Vermont who was stopped for a minor traffic violation in New Jersey. His firearms were unloaded, locked in hard cases, stored in the trunk exactly as federal law required. Didn't matter. He was arrested, charged with unlawful possession, and spent over $70,000 in legal fees across 3 years defending himself before charges were dropped. Or the Texas woman driving to Maine for a family visit who was pulled over in Maryland. She had a legally registered handgun, properly secured during transport. She disclosed it immediately when asked. She was cooperative and polite. None of it mattered. She faced 18 months of criminal proceedings and nearly lost her job, her savings, and her freedom. We all know the horror stories of travelers spending $60,000 in legal fees just to prove they were passing through. New Jersey alone arrested over 900 people in the last 5 years for unlawful possession during interstate travel. As of January 2026, the geographic trap is dead. The new federal protection, an expansion of the Firearm Owners Protection Act, provides an absolute shield for travelers. If your firearm is legal where you start and legal where you end, you are federally protected for the entire journey. The court has specifically ruled that you are allowed to stop for gas, meals, and overnight hotel stays without losing your protection. The burden of proof is now on the police to prove you weren't traveling, rather than on you to prove you were. If you are stopped while traveling, you now have a federally backed statement to use. I am traveling under federal interstate protection with a lawfully owned firearm secured for transport. This single sentence, backed by the 2026 rulings, serves as a total shield against the felony charges that used to ruin lives. This single statement, combined with proper transport procedures, provides complete protection against the felony charges that used to destroy lives. Let's review. These 10 laws are active right now, but they only protect you if you are informed enough to use them. Historical precedent requirement. Modern gun laws must have founding-era analogs or they fail. Prior restraint prohibition and officer liability. You cannot be required to justify constitutional rights, and officers face personal accountability. Emergency confiscation restrictions. Firearms cannot be seized without full due process. Warrantless database prohibition. Digital registries are being destroyed with criminal penalties. Financial monitoring restrictions. Banks cannot surveil purchases without warrants. Background check and permit time limits. Automatic approval after deadlines. Ammunition equivalency doctrine. Ammo receives the same protection as firearms. Dealer protection standards. No more zero tolerance for paperwork errors. Compliance inspection prohibition. All searches require warrants. Interstate transport immunity. Travel is federally protected from start to finish. The bureaucracy won't tell you your rights have been restored. You have to assert them. The legal landscape has shifted in your favor for the first time in a generation. Millions of Americans now have legal protections that were impossible just months ago, but the system won't tell you that. It's up to you to know your rights and use them. If you found this deep dive valuable, do yourself a favor. Share this with every gun owner you know. This information is the difference between being a law-abiding citizen and a victim of an outdated legal system. Drop a comment below. Which of these 10 changes surprised you the most? Have you already seen these new rules being put into practice in your state? The silent legal earthquake is real, and the only question now is whether you'll be informed enough to benefit from it. Stay informed, stay legal, stay armed.